very much, Chair, for giving me the floor. First of all, I would like to thank all of you, especially our hosts, for the warm welcome, which, knowing the legendary Portuguese hospitality, does not surprise me. And it's a great honor and privilege for me to be invited here today to this conference. And of course, the current COVID situation necessitates a hybrid meeting, and so therefore I greet you all wherever you are. Allow me, by way of introduction of the topic of today, to share with you a personal observation. At the beginning of the academic year in the Netherlands, I have often the pleasure of addressing first-year law students at my university with a presentation on the core elements of the rule of law, and especially, of course, the independence of the judiciary, which is of paramount importance. And I often begin my lecture with a remarkable insight from a great American statesman, Alexander Hamilton. In the summer of 1787, New Yorkers were about to ratify a constitution for the United States. And in a series of newspaper articles, Hamilton argued that only a federal judge could guarantee constitutional rights and provide an effective check on state power. At the same time, Hamilton had to convince his political opponents that the unelected judiciary would never dominate the other branches of government. And drawing on the ideas of Montesquieu, he deliberately portrayed the judiciary as the least dangerous branch of government, a branch that is inherently weak because it cannot control either the country's financial resources or the army. Hamilton's reassurance to his opponents can easily be turned into a warning. The rule of law is rarely safe in the hands of politicians alone. The independence of the judiciary is a principle which, by its very nature, can only be poorly protected by legal provisions. And such provisions can all too easily be changed by the legislature, or misinterpreted, or even ignored by an ambitious government which feels secure and confident if it can rely on a comfortable majority in Parliament. And until recently, I had a hard time convincing law students of the practical relevance of Hamilton's insights. Today, many see little danger to the fundamental values that underpin the proper functioning of democracy and the legal system. Yet, the past 5 years have given me the excellent examples I was looking for to illustrate my lecture on judicial independence. Because, to everyone's surprise, we have witnessed the rapid erosion of the rule of law in Poland. It's hard to understand how quickly a great and admired country, which played a leading role in overcoming the former division between Eastern and Western Europe, could fall back in so little time. And who would have expected that after the proclamation of the Universal Declaration of Human Rights in New York, exactly 73 years ago tomorrow, the courts in Europe should remind the member states once again of the principles of justice, which are also the basis and the essence of the Council of Europe and the European Union. Alexander Hamilton's warnings are today more appropriate than ever. If, as we have seen in Poland, a member state gets to the point where a government abuses an election victory by introducing LGBT-free zones for populist reasons, and judges are not supposed to protect the rights of the people concerned, then the judiciary indeed has become the least dangerous branch of government. So my newfound examples are no cause for great happiness. Yet I suppose they help to reach the point where effective legal education begins by exposing to young people the nasty face of a legal system that shows little interest in justice. I'm afraid that more useful examples will follow for my by denying primacy and precedence of EU law over national law. And I'm equally concerned about the Hungarian case decided by the Court of Justice a fortnight ago. The Court of Justice had to remind the Hungarian Supreme Court that no disciplinary proceedings can be brought against the lower national court on the sole ground that it has referred a question to the court for preliminary ruling. Even more disturbing, perhaps, is that the referring Hungarian court had originally intended to draw the Court of Justice's attention to inappropriate external and internal pressure within the Hungarian judiciary. The sad conclusion is that we are still in the midst of a crisis of the rule of law and not in its aftermath. Yet there is also good news. For both courts in Europe have acted swiftly and built up an impressive body of case law in order to respond to the crisis in Poland. I assume that you are well aware of the outlines of recent case law on the independence of the judiciary. Therefore, today I will focus mainly on the workability of this body of case law and on the relationship between national judges and the Court of Justice. We should be grateful to the Portuguese Association of Judges, one of our hosts today, for the opening move in Luxembourg. The case of Associação Sindical gave the court the opportunity to bring the independence of judiciary in the member states under the protective mechanism of the treaty. For the reasoning behind its judgment on judicial independence, it relied on previous law, which had always leaned heavily on the Human Rights Court's earlier findings in this regard. And by doing so, the court provided itself with the legal framework, you may also say ammunition in this case, that it would apply 6 months later in the Selma judgment. In retrospect, all of this was no coincidence. It is an open secret that in the Portuguese case, the Court of Justice had sent a strong signal to Poland and others and was preparing for a future engagement with what might be independent Polish courts. The Selma case, to which I shall come back in a moment, was in turn followed by a flood of judgments from the courts in Europe. I only mention the other landmark decisions on the lowering of the retirement age of judges and public prosecutors, and on the newly created disciplinary chamber of the Polish Polish Supreme Court. And this year also the Court of Human Rights stepped into the ring to stop the further backsliding of the rule of law in Poland. It found numerous violations of the Convention and an impressive long list of newly communicated cases from Poland is waiting now for decision or judgment in the Strasbourg Court. You will forgive me and perhaps even thank me for not discussing the abundance of case law in further detail. The strong messages from both the Luxembourg and Strasbourg courts were welcomed in the member states, and they also satisfied moral indignation. For now, I would like to dwell on the difficulties encountered by national courts in applying the case law of the Court of Justice, particularly in cases of surrender, as this is where the consequences of the Polish rule of law crisis have become particularly apparent. In Selma, the Court of Justice instructed the national courts to make a multi-layered assessment in surrender cases. The executing authority must determine specifically and precisely whether there are substantial grounds for believing that a person will run a real risk if he is surrendered to a member state. The court does so on the basis of the following elements: on account of systemic or generalized deficiencies of the independence of the issuing member state's judiciary, having regard to his personal situation, as well as to the nature of the offense in question, and the factual context, and, this is remarkable, in the light of the information provided by the issuing member state. So the court sets the bar very high in Selma. Only to a very limited extent can an executing authority refuse to execute an arrest warrant. In practice, requests for surrender from Poland are rarely refused. I only know of one case in my country. And there is widespread concern also among judges that the Selma test falls short. The court responded to these concerns last year, but not to everyone's satisfaction. It ruled that even in the case of established systemic shortcomings, a concrete assessment of the case is necessary. Such an assessment should not assume that there are substantial grounds for believing that a person would face a real risk of not receiving a fair trial following his surrender. In light of the strong position the Court of Justice takes on surrender to Poland, the recent decision of the Vestfold District Court in Norway is worth noting. The court refused surrender in that case on the grounds of general deficiencies in judicial independence in Poland. The Norwegian court adapted the Selma test in that the greater the general risk of a breach, the less specific grounds for a violation of the right to a fair trial should be required in a particular case. According to the Norwegian court, the Court of Justice does not leave the national court sufficient discretion to provide effective legal protection in surrender cases, and therefore the court's strict line is adjusted to a more realistic approach of a real risk of an unfair trial. The Vestfold judge's decision has been appealed in Norway. But it is certainly not the first time that the national court has disagreed with the Court of Justice on the level of legal protection in human rights matters. It goes, of course, without saying that the Vestfold court goes much further than the Court of Justice, and that his ruling is, to put it mildly, not even in the spirit of the Court of Justice. But in its defense, I would like to point out that also new preliminary questions from the Irish Supreme Court and the Court of Amsterdam are pending now before the Court of Justice. And in those cases too, the question is essentially whether the shortcomings of the Polish judiciary are such that they are in themselves sufficient to constitute a real risk to the right of a fair trial. I think it's important to point out here that a difference of opinion between judges is not in itself a cause for concern. On the contrary, it can be a very valuable feature of jurisprudence. And let us not forget that in many member states, the development of law is often initiated by lower judges. A recent dissent from a first instance court and a subsequent reconsideration by a higher court have an intrinsic value for the administration of justice. And in that way, the law remains what we say a living constitution. In this connection, there is often talk of the famous dialogue between judges at European and national level. But on a closer inspection, it is not very substantial. The preliminary ruling procedure is not in itself a dialogue if it is limited to a Q&A format. A real dialogue between courts presupposes reciprocity and requires a serious exchange of arguments with a willingness not only to listen to each other, but also to change position if necessary, on the basis of reasonableness and preferably conviction. Exemplary is the fact that some national surrender judges do not find sufficient resonance with the Court of Justice on the workability of its jurisprudence. If true, this is a serious matter. when signals come from member states that the Court of Justice provides insufficient guidance for effective legal protection, and when its jurisprudence is called unrealistic, then the Court cannot let this pass without providing a convincing counter-argument. Let us also not forget that dialogue with the Court of Justice also serves a legitimate self-interest of national courts. Involvement and responsibility in the development of the Court's jurisprudence also contributes to the credibility of judges at a national level and strengthens public confidence in judicial fairness and justice. After all, it is the national judges who have to apply European law as interpreted by the Court of Justice in concrete cases. And this is sometimes not an easy task for the courts. For many in the member states, it is difficult to understand how a systemic weakness in another country's legal system can be remedied under the Selmer test by reassuring statements from authorities in that country who are themselves part of the problem. Justice should not demand the utmost of people's imagination. Admittedly, the input of national judges into this dialogue is still very limited. That is a shortcoming, and we need to change it. With an anticipated further integration of the member states into the EU, and there's no doubt about that, the Court of Justice will have to rule much more than before on fundamental shortcomings in one of the member states. In this respect, the Court of Justice cannot do without the critical input of national courts, if only for the sake of its legitimacy and the cooperation at national level that it needs. Therefore, dissent from the national courts should be valued positively and not considered too easily as rebellion or disobedience. This puts, of course, great responsibilities on the shoulders of national judges. They will have to develop a proactive and strategic attitude in order to contribute effectively to the development of European law. Meanwhile, the Court of Justice in Luxembourg is not to be envied in the role it has to play. It is quite understandable that it does not want to be tempted as a judicial authority to make a general political judgment on the rule of law in Poland. After all, a crisis of the rule of law in a member state is essentially a political issue for the European Union, not a legal problem to be solved first and foremost by judges, insofar as there is a role for judges here. The Court would certainly be stronger if the political European institutions not only spoke out strongly against violations in the member states, but also took full responsibility for acting accordingly and effectively. And I fully agree on this with Laurent Peck. More rule of law reports will not help. It may even weaken the position of the Court of Justice. In any case, we must ensure that disagreements between national and European judges on the way forward do not become a false argument for European politicians to postpone difficult decisions in the current crisis any longer. If I may, I would like to make a last comment on so-called additional findings of the Court of Justice's case law. This year, there were elections in the Netherlands after the government fell over serious and systemic shortcomings in the protection of individual rights in the so-called child care allowance case. As a result, the lower house in my country took the remarkable step of asking for the first time the Venice Commission for an opinion on the rule of law in my country. And although the Venice Commission recently concluded that the Netherlands is a well-functioning state with strong safeguards for the rule of law, it did find reason to make urgent recommendations that affect all branches of government, also where the proper functioning of the courts is concerned. And this example made me wonder whether the case law of the Court of Justice not only gives guidance to the courts of the member states, but also has beneficial effects on a meta level. The current crisis of the rule of law and the reaction to it by the courts in Europe make a moral appeal to all member states and encourage them to carry out self-evaluation, even if there is no immediate cause for concern. After all, why should what is currently happening in Poland not also be happening here? The case law of the court is particularly useful here for a regular health check of everyone's legal system. Ladies and gentlemen, I must have used up the speaking time that the chair so generously granted me until now. I promised her to talk 22 minutes and 43 seconds. But allow me to make a concluding remark. In 1940, the famous Brazilian poet Carlos Drummond de Andrade expressed his deepest concern and anxiety about what awaited him in the coming years. And I realized that my reflections today on the fragility of the legal systems may have the same sad effect on you. But do not let my sentimento do mundo leave you with a gloomy outlook for the future. For the inherent fragility of the legal system should not be confused with weakness. The sensation of vulnerability serves a purpose. It warns us of nearing danger. It defines what is essential. It encourages us to choose which sides we are on. And it unites in times of crisis. The courts must protect the rights of the individual. European political institutions must lead the community to a secure future. Let us respect their responsibilities and, above all, encourage them to put words into action. What I find heartening and reassuring today is that in the current crisis, almost the entire European community is speaking out fearlessly about the protection of human rights. And this is why I'm tempted to read Carlos de Andrade's poem in a spirit that may not quite reflect his sad feelings at the time. But why couldn't a poem, just like the law, be a living document and help us move forward? After all, two hands and the sense of the world, as the poem reads, may not seem like much, but it is certainly a good start to building Europe's future. Thank you very much.